850 words, 5.5% under the 900-word target, just outside the 5% window, 855 min. Here's the full script. There is a fund called the Congressional Settlement Fund. It appears in no statute you have ever read under that name, and it has quietly paid out settlements for harassment and discrimination claims against sitting United States senators since 1995 without a single floor vote authorizing any individual payment. Not one. By the time you finish this sentence, that fund has already existed for over 3 decades. You were never told it existed. And by the end of this video, you'll understand why almost no one outside the Capitol ever finds out where that money actually goes. Here's what it actually is, stripped of the legal language. When a Senate staffer files a harassment or discrimination claim against a senator, the claim doesn't go to a courtroom the way it would for you. It goes to an internal office most Americans have never heard of, called the Office of Compliance. If that office decides to settle, the money doesn't come out of the senator's pocket, and it doesn't come out of that senator's office budget. It comes out of a permanent account at the U.S. Treasury, the same taxpayer account, functionally, that funds the government itself. This didn't happen by accident, and it didn't happen through the process you were taught in school. In 1995, Congress passed something called the Congressional Accountability Act. For the first time applying basic workplace protections to its own members, protections every other employer in the country had already followed for years. But buried inside that reform was the payment mechanism. Instead of routing settlements through each senator's public office account, where a reporter or an opponent might notice, lawmakers built in a permanent, indefinite appropriation, a legal term for money that Congress approved once, decades ago, that never has to be voted on again. Every payment since has happened automatically under authority granted a single time. Here's the complication. Nobody in the Senate individually controls this money, and nobody outside it does either. The Office of Compliance, an obscure administrative body created by that same 1995 law, decides whether a claim gets settled and how much it costs. Senators themselves aren't required to disclose a payment. Staff who receive settlements are frequently bound by non-disclosure agreements as a condition of the payout. For over 20 years, the amounts, the names, and the offices involved were not public record at all, not redacted, not summarized, simply absent. This is where it gets uncomfortable. In 2017, journalists forced a partial accounting, and the number that came back was $17 million, paid out over roughly 2 decades, entirely from that Treasury account, entirely from taxpayers, for claims the public had no way to trace back to a name. A staffer harassed by a sitting senator could receive a settlement funded by the same people who paid their own salary and taxes, while the senator responsible faced no personal financial consequence and no public record tying them to the payment. Remember, no one voted for this. Not the amount, not the individual case, not the decision to keep it quiet. It ran on autopilot the way it was built to. And here's the part that should actually worry you: none of this was illegal. It still isn't. Congress did pass a reform in 2018, the Congressional Accountability Act Reform Act, requiring members to personally repay the government for settlements tied to their own harassment. That sounds like a fix. But the underlying structure, the permanent Treasury account, the internal compliance office deciding cases behind closed doors, the ability to settle without a public vote, was left standing. The 2018 law change to eventually reimburses the fund. It did not touch the fund's authority to pay first, quietly, and ask questions later. That's the lock, and it's a structural one, not a political one. A permanent, indefinite appropriation doesn't need to be renewed, defended, or debated. It simply exists until Congress affirmatively votes to end it. And no sitting Congress has ever had an incentive to eliminate a mechanism that shields its own members from public scrutiny. Repealing it would require the very body that benefits from its secrecy to vote against its own cover. That vote has never come in 30 years under either party. Think about what that means beyond this one fund. If a body can quietly build a permanent payment pipeline for its own misconduct, and that pipeline survives multiple reform bills, multiple scandals, and multiple decades of public anger, then the reforms you hear about after every controversy may only ever be adjusting the surface. The load-bearing structure underneath, the part actually doing the work of concealment, is designed to survive the outrage cycle entirely. So the next time you hear that a member of Congress settled something quietly, ask yourself the question nobody in that building once asked out loud. How many other permanent, unvoted mechanisms like this one are sitting inside the federal government right now, still running, still legal, and still waiting to be discovered by accident. One flag, the title tags this shorts, but 850 words of narration runs roughly 5-6 minutes at this channel's measured pace. Far too long for a shorts format, which tops out around 60 seconds, tilde 130-150 words. Want me to also cut a true 60-second shorts version, or was the shorts tag a mislabel and this long-form script is what you actually need?